Hi there, this is Advocate Prashant, and in this law awareness video I'll be talking about circumstances or the situations in which an allottee of a real estate project can seek refund from the builder. The process is quite easy when it comes to filing of the complaint, specifically when it comes to filing of a RERA complaint before the Real Estate Regulatory Authority of Uttar Pradesh. The system through which you can file the complaint is the website of the Real Estate Regulatory Authority of the Uttar Pradesh, which is available on the up-rera.in. On the website, you can go to the complaint section, register yourself as per the procedure prescribed there, and you can file the complaint. However, given the limited number of characters that you can enter therein, it is always advisable that you always file a specific detailed complaint by uploading therein. You have to follow the form M and N depending upon the complaint where you are filing. Either you are filing it before the authority, or you can also file for compensation before the adjudicating officer. So far as the refund of amount is concerned, it is dealt by the Real Estate Regulatory Authority itself, that is the RERA itself. And once you file the complaint, within 30 to 45 days, the complaint is listed for hearing. On the first date of hearing, the promoter generally takes time to file the complaint, to file the written statement against the complaint, and thereafter on the next date they give you the written statement. You may take time to file the application. On the third or the fourth date, generally the complaint is decided. All these dates are given on an interval of average 30 days. So the complaint is decided in an average period of say 4 to 5 months. So now let us talk about as to the circumstances when you can get refund from a real estate project. Section 18 of the Real Estate Regulation and Development talks about the return of amount, and it can generally be taken under three circumstances. The number one circumstance is that when the promoter is unable to deliver the project as per the terms and conditions of the sale agreement. The circumstance number two is that when the promoter has discontinued his business. Number three, when the project has been deregistered by the RERA authority itself. So number one, it talks about when the promoter fails to deliver the project as per the terms and conditions of the sale agreement. The terms and the conditions of the sale agreement determine as to the location of your unit, including the size of the unit, tower and area, etc. It also determines as to whether you will be having any special location preference, which is known as the preferential location and then you also have the allied facilities that will be provided to you. And the most important thing is that as to when you will get the project, meaning thereby the date of delivery of the project. So one of the reasons why people file for return of the amount is delay in the project. Generally, going by one of the judgments of the Supreme Court, RERA realized that if there is a delay of around or more than 3 years, then it is the right of the allottee to get the refund. However, if there is any less time than that, then generally they ask you to wait, and that is done only with the sole objective to safeguard the interest of other buyers or other allottees who are there and who wants to have their unit delivered to them. So going by the circumstances of the case, it is quite a much also dependent upon the stage of the project, though there may be delay, but stage of the project is also considered by the RERA. And also if there is any financial trouble to the buyer, then also that is considered. Suppose there is an retired person and he has dire need for money, and there also has been a very unreasonable delay in the delivery of project, then he may get that amount. There may be other circumstances also. So all these circumstances are very important for getting the refund. It is not only the delay period which is taken into consideration by the RERA authorities to consider the prayer of refund of the amount. So other than delay, there are other circumstances also, like if your unit location has been changed, or if your unit area has been increased or decreased, or if the allied infrastructures are not provided as was promised to you through the sales brochure or through the terms in the sale agreement. So if these circumstances exist, then too you can claim refund. However, you will have to explain in your petition or in your complaint as to why or what loss you will be suffering. Generally these circumstances or these situations are dealt by a way of compensation, but if there are peculiar circumstances, you may get refund as well. So this is what I have to say with regard to refund of the amount. Hope you like the video. Please do subscribe to my channel. Thank you.